Hello, I'm David DeLugas, the $99 lawyer. This evening, I'm going to answer the question, what do I do when I've been served with a summons or with any other document that looks pretty official? Well, this is actually a very easy question to answer for me as an attorney. It is not uncommon for someone to be served with a summons or to receive some other document, maybe an order, um, certified mail, maybe by a sheriff, a marshal, or a private process server. Somebody calls out your name and asks if that's who you are, and then hand you some documents. Let's make sure you do one thing: read them, look at them carefully. Somewhere within those documents, it's likely to say you have a certain period of time, 30 days, 10 days, to respond to the summons or, again, whatever else it may be called in your jurisdiction. Now, don't ignore it. Don't just throw it in a drawer and say, well, I don't need to bother with that. Even if it appears at the top that it's coming from a state you haven't been to ever or recently, don't ignore it. Don't ignore it if it even looks as if it's frivolous, it's just a waste of time, something completely absurd. This person, this company, you've never done business with them, you don't know who they are, and they're suing you. And let me tell you why. Because if, in fact, there is no valid claim against you, then you need to establish there's no claim against you. If the jurisdiction is wrong and doesn't exist, and you should not be compelled to go to another state to defend yourself in some civil case, well, of course, that may well be true, but if you don't go and have someone enter what's called a special appearance or something to that effect, and establish that the jurisdiction's improper or they've identified the wrong person, what will happen is a judgment by default will be entered against you, most likely. And the damages could be substantial because you're not there and no representative is there to defend or to try to reduce or keep the damages reasonable. The plaintiff, whoever is sued, will have a field day, will have no opponent, nobody questioning the evidence, because that's not the judge's job. The judge's job is not to question the evidence other than its legitimacy or whether it can be introduced, whether it has any truthfulness associated with it. But understand, if a witness goes under oath and testifies, that's going to likely establish through that evidence what the damages are. So, what's the lesson? If you get something handed to you, read it carefully. If you don't read, make sure somebody in that language, make sure somebody else reads it. Have 2 or 3 people take a look at it. Scan it, email it, get in touch with me, the $99 lawyer. Let me take a look at it. But do not ignore it. Do something. Now, when I say do something, again, your range of options include defending it fully. And again, you might be in a position to ask for reimbursement for your attorney's fees. And if you don't hire an attorney, you should be able to ask for reimbursement of your out-of-pocket expenses if indeed it's a frivolous lawsuit or frivolous action, whatever it may be against you. It could be a neighbor seeking to impose some injunction against you where you're not allowed to do some certain act, something that they're bothered by. Now, again, no matter how absurd you may think it is, if you do nothing, then you're in the hands of the court, and a court order, by default, is not going to be appealable. You can't later try to correct it, with some limitations. Of course, you might be able to correct it if indeed the jurisdiction never existed, and the judgment from another state is brought to your state for what's called domestication. So it's established under the Constitution's full faith and credit clause, which means judgments established in one state, if done in accordance with due process, will be given full faith and credit in another jurisdiction. That way you don't have to relitigate the merits of the case in the state where you might live if in fact there was jurisdiction in another state. Let me tell you a quick story. When I was a young attorney, I represented a shoe company, a shoe retailer, just a small shoe retailer. that had purchased product from a company out in Oregon. You may have heard of the company in Oregon. It's called Nike. Now, Nike, as part of its credit application by retailers who want to buy product and then pay for it 30, 60, 90 days out, whatever the credit terms may be, has that retailer sign the credit application, and within the credit application it says, if approved for credit extension to that business or the individual, then that business and individual agree in the event there's a dispute, money owed or claim to be owed, that they will submit to the jurisdiction of the state of Oregon. Now, is there anything wrong with that? No. If you have the business clout or you have the leverage to establish terms that are favorable to you, you would do the same thing. What Nike didn't want to do was go from state to state and have to sue in your or in the retailer's home state and hire lawyers all around the country. So instead, they pretty much made it, hey, you want to buy product from us on credit. If you pay cash, not a problem. If you want credit, you have to agree that if there's an issue with regard to what you owe us or what we claim you owe us, we can sue you here. Naturally, that made it very difficult for retailers to contest the accuracy of the statement of claim, perhaps, or of the accounts receivable Nike's putting forth. But that said, and I'm certainly not criticizing Nike, what my point is that if somebody contends that they have the right to sue you in a state where you don't live, please don't ignore it. Do something about it. You won't always have to hire an attorney, but you definitely need to respond to whatever the court has compelled you to do, which may be simply as far as respond within 30 days of the date of the service upon you. Now, if you'd like any help in assessing the situation, please consult with an attorney or consider booking a session with me, the $99 lawyer. Thank you so much.